And hello there, and welcome once again to the Disability Law Show. Good to have you for the ride. Over the next half hour, you're going to learn lots. That's much we can guarantee you. John Scholes here, James Fireman there, Samfiru, Tumarkin, LLP. Want to reach out to James and his team. When you don't see us on TV, you can always do so. The options are phone call and email. How about that? 1-855-821-5900. help@disabilityrights.ca. We'll give you some more contact information throughout the show. Main topic in just a bit is going to be how to return to work successfully from a disability leave. That, your emails, and some other reach out from our various TV shows and other times we're on the radio as well. But James, we always kick things off with the week that was. Get us warmed up, pal. What do you got this week?
I'd like to take a couple minutes at the top and just talk about disability claims involving mental health care, which is a very big issue, and I would probably estimate 70–75% of the claims that I handle are either primarily or secondarily mental health claims, where there is an element of mental health that is impacting disability, impacting the person's ability to work. And why this is a really big issue, one is because it's treated often differently from physical, and that's another topic that we'll talk about throughout the show and on other shows. But what I'd like to talk about is the access to mental health care. Access to health care in general is a problem. It is great that we live in Canada, a country where we have access to free health care, but as we all understand, that comes with other issues as well. And getting access to that health care is really problematic, especially if you're outside of an urban center. Even in urban centers, it can be very difficult. But if you're living in a rural town and you need access to mental health care, that can be incredibly difficult. It can mean waits of a year, even 2 years, or possibly having to travel an hour, 2 hours outside of your home area in order to have treatment, or having to settle for virtual treatment, which is fine if it's all that's available, but is not ideal in most circumstances. And so these are issues that people are faced with, and it's incredibly problematic, especially at the application phase. Because in order to successfully apply and get approved for disability benefits, the policy is going to require that you have medical support. That doesn't necessarily mean you have to have a specific diagnosis. It's something that we talk about often on the show, that being entitled to disability benefits doesn't require a specific diagnosis, but it does require a medical condition. And even if that medical condition doesn't have a name or doesn't have a name yet, it still has to have the support of someone in the medical community, preferably a doctor. If we're talking about mental health, a psychologist, a clinical therapist are all fine as well too, but you're going to need to have that support. And that can be really problematic for somebody at the outset of a claim who has difficulty just getting in, just finding someone that can say, okay, this person is suffering. We're not sure what it is yet. It may be depression, it may be anxiety, it may be something else, but there is a medical condition here. So what do you do if you find that you're in that position? If you are struggling with your mental health to the point where you're not able to work, but you don't have access to mental health care, or at least not immediately. Right. Well, first and foremost, do whatever you can. So that starts with seeing your GP, your family doctor. Now, family doctors, although they are not necessarily trained explicitly in mental health, that is part of their medical training, and they should be able to at least initially be able to treat that and assess what is going on, and importantly then refer you to a specialist that can help, either a therapist or a psychiatrist that can help you going forward. They can also prescribe medication. Now, is that going to be sufficient for the insurance company? Maybe, maybe not. It depends on the circumstances. But what you need to be able to show at a bare minimum when you're applying is that you have done what you can reasonably do in your circumstances. If the fact of the matter is that there is no therapist living within 2 hours of you, and the wait list for seeing a psychiatrist is over a year, then the insurance company can't reasonably say, you're not being treated by a therapist or a psychiatrist, and therefore we're not going to pay you. But they can say, well, you haven't done everything you can possibly do if you haven't spoken with your family doctor about it, if you haven't looked for other opportunities to provide at least temporary treatment that may be better than nothing. There are community groups often that can help. There are online forms of therapy that can be helpful. Is that going to solve your problems? Probably not. I'm not really in a position to say. But at the very least, you want to be able, when you're applying or dealing with the insurance company, you want to be able to say, look, I am doing everything that I possibly can. It is not on me that our healthcare system doesn't have mental health care providers in our area, or at least I'm not going to be able to see them for 6 months or a year. But I've done everything else that I can. In those circumstances, if you have the support of your family doctor, if you're not able to get any further treatment, at least at that time, if your insurance company turns you down in that circumstance, even though your family doctor is saying that you are not able to continue working, then you should be entitled to your benefits. And if your insurance company denies, then you absolutely have a valid right to bring a legal claim and sue your insurance company for the benefits.
Where do you stand if the insurance company says, oh, we'll approve you, but we got a therapist that's a 5-hour bus ride, so grab a ticket, get going?
Well, that's an interesting question. I don't know that I've come across that particular hypothetical. But first of all, my instinct is always when an insurance company is saying, go see our therapist, I don't like that. But when you're in a circumstance where you don't have any other access to therapy, sometimes you have to choose the lesser of two evils. And if you can get immediate treatment, it is probably better to go through with it and see what's going to be there, especially if your insurance company is taking the position that if you don't, then we're not going to pay for your benefits. I would, though, if your insurance company is saying, no, you have to go see this therapist and there's nobody else available, so you agree to do it, I would make sure that they are paying for whatever transportation is necessary to get you to and from.
Because it's their call. They're the ones who are suggesting.
Absolutely.
Yeah. Pocket Disability Lawyer, interesting website if you've never used it. James and Savannah and the rest of the team put this together about a little over a year ago. It's just a series of drop-down menus and questions. Takes about 30 seconds. It will let you know where to go with your inquiry as far as if you're going to be on claim. Should you apply? Should you call James? It'll let you know. PocketDisabilityLawyer.ca is the way to do that. PocketDisabilityLawyer.ca. And email. Mention that off the top as well. help@disabilityrights.ca. First one for the show, James, comes from Hannah. Says, after a serious car accident a few years ago, I applied and was approved for LTD. The insurance agent for my file is now requesting I apply for CPPD. That's Canada Pension Disability. Does this mean they are trying to push me into a basic disability program? What should I do here? What do you think, pal?
Well, so CPP disability comes up a lot when we're dealing with long-term disability claims. So just to take a step back for a moment. The Canada Pension Plan, most people who are working are paying into it. And as long as you've paid into it, I believe it's at least 4 of the previous 6 years before you become disabled, you have the right to apply for CPP disability. This has got nothing to do with your age. When people think of CPP, typically they think, okay, well, I can't get that until I'm 65. Right. It's actually 60, by the way. But in any case, if you become disabled, you have the right to apply for CPP disability benefits as long as you've been paying into CPP for the minimum 4 to 6 years. But the test for that is more stringent. It requires a severe and prolonged disability. That's going to be tougher to get approved for than most LTD policies. That's just a fact. So even if you apply for it and you're entitled to LTD, you may not get approved. You may. It depends. But the thing of it is, if you are approved for CPP disability, most long-term disability plans, especially that are part of a group plan, are going to contain a provision that allows your insurance company to take that CPP disability as an offset against whatever they're required to pay. So let's say, for example, you're entitled to $4,000 in long-term disability benefits each month from your insurance company, and you get approved for $1,000 through CPP disability per month.
You ain't getting 5.
You're not getting 5. You're getting the $1,000 through CPP disability, and then your insurance company is just going to pay you $1,000 less. So the net amount is the same, technically. And so you may be thinking, well, why would I bother? Well, the reason is, if you look closely at the policy, almost all of them contain language that says, if you don't apply for CPP disability, your insurance company can then estimate what you would get if you did apply and were approved, and then just take that as an offset, even though you've never actually applied.
Right.
So if you don't apply, you're in the worst case scenario. You're not getting the CPP disability.
And you're getting dinged for it.
And you're getting dinged for it.
Right.
So apply. If you get approved, you're in the same position that you were. If you're not approved, then the insurance company can't say that they're entitled to an offset. And also, the added benefit, if you are approved, that is pretty compelling evidence that you should be entitled to ongoing LTD benefits.
Because of the tougher test.
That's right. It puts your insurance company in a more difficult position going forward because we know sooner or later your insurance company is going to start looking at ways they can get out from underpaying you those benefits until you're 65. If you continue to get the CPP disability benefit, it doesn't mean they can't, it doesn't mean they won't, but it means it's more difficult for them. And if they do, it means that there's a pretty compelling argument to bring a legal claim to recover the benefits if your LTD insurer eventually does cut you off.
And while you do that, you'll still have a stream of income from CPP, which is nice. There's actually no negative to it, really?
That's,
negative to it?
I agree with that. The one exception, the one negative to it is that CPP disability is a taxable benefit. So if you have a non-taxable policy, the net amount in your pocket is a little bit less because whatever you get for CPP disability is taxable, but you can also apply for the disability tax credit. And because it's our federal government, even though the test is pretty much the same for the disability tax credit and CPP disability, there are two different ministries that are controlling it, so they're two separate applications. So it is a little bit more of a pain in the butt, but it is worthwhile. Apply for both.
It's interesting, too, because as you've said numerous times, we say every week on this show that once you're approved and on disability from your long-term disability insurer, yeah, sooner or later they're going to start poking around ways to get you off the books and get you off there. I've heard, not sure this is true, but once you're on CPP, if you get approved, they don't really check back as often when you're getting the amounts.
I mean, that's probably generally true.
Right.
But it is idiosyncratic. It depends.
Sure.
It really just depends on not even just your insurer, but the particular claims handler assigned to your file.
Right.
There are some that are going to be more aggressive. They may be less aggressive than they would have been but for the CPP disability approval, but still far more aggressive than some other claims handlers. So it really is a little bit luck of the draw and a little bit your circumstances.
Main topic is just ahead after a short break, as mentioned off the top, how to return to work successfully from a disability leave. That is coming up with James. He'll fill you in. I'll ask him the questions. You'll get some answers. In the meantime, ask your own questions. That's help@disabilityrights.ca for email. And the phone number, 1-855-821-5900 anytime as well. We'll continue more of the Disability Law Show is coming right up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Disability Law Show. Good to have you along for the ride for this week. John Scholes, James Fireman. Reach out to James anytime to discuss your matter, whether you've been cut off or thinking of applying or otherwise. It's always good to make that phone call, 1-855-821-5900. You prefer the email route, you can do that, help@disabilityrights.ca. But returning to work successfully from a disability leave, that is the main topic. I'm going to ask James. He's going to answer it. I'll simply ask it because that's all I'm capable of. James, you should only return to work if you have received approval from your treating doctors. How about that?
For sure. And I want to back up just a second and talk about returning to work generally. If you watch the show, if you listen to our radio programs, or if you have called me for a consultation, you will have heard me say at some point or another that if you are able to return to work, if you feel like you would be successful in returning to work, and you have the support of your doctors, you absolutely should. It is better for you if you're able to earn your income at 100% than hoping that your insurance company is going to pay you the 2/3 or whatever your LTD benefit is set at going forward, or worse yet, having to bring a lawsuit to try and recover that from them. So I always encourage people, whatever their circumstances are, if they feel that they have improved sufficiently to be able to return to work, to pursue that. Now, the first step, as you've already pointed out, is making sure that you have the approval of your treating doctors. So if you are feeling optimistic, and that, by the way, actually should be step one. If you feel like you're optimistic that you might be able to successfully return, you're not going to know for sure, but if you feel as though you are capable of doing it and there's a good chance that you can succeed, then it's time to go this route and talk to your doctor about it. If your doctor or therapist or whoever your primary care provider is for whatever it is that is disabling for you from work or has been disabling you from work, if you go to see them and you tell them about your symptoms and about presumably the improvement in your condition and your belief that you would be successful in returning to work, that you'd like to try, you talk to your doctor. If they agree with you, then you can start pursuing it. But if they say no, if they say, listen, I know you're feeling good, but I've seen this before, you need to just give it a little bit more time. Yep. Give it another 2 weeks, 2 months, whatever it is. Listen to your doctors, right? Listen to your therapist. You know, they have much more experience than you have, than I have. So they're there for a reason, and you should trust in them. Now, if they're being crazy, overly conservative, at a certain point, I suppose it might be time to get a second opinion. But generally speaking, talk to your doctor first and rely on their advice.
That second opinion's interesting. It kind of dovetailed into the question I'm just going to ask as an aside before we move on to number two. What if their doctor, meaning the insurance company, what if their doctor says, I think you're ready to go back? And my doctor says no. Yeah, but we think you're ready to go back.
Yeah, if the insurance company doctor says you're ready to go back, that doesn't change my opinion of anything. If the insurance company is saying, our doctor says you can go back and we're going to stop paying you benefits if you don't, then you have a decision to make, assuming in this scenario that your own doctor has said, no, you're not ready. My general advice, as I've already said, is listen to your doctor. If your doctor says you're not ready, then listen to them. But as a practical matter, some people have to be able to have income coming in, whether it's from benefits or from work. And if your insurance company is putting you in that position, where your doctor is saying you're not ready, but they're saying we're not going to pay you benefits if you don't, you're going to have to decide whether or not you can at least make an attempt, whether it's something that you can try to do and see if it's possible, even if you're not feeling it and even if your doctor is saying it's not a good idea. In that scenario, if you're in a situation, let's say you have to have that money coming in or you won't be able to pay the mortgage, whatever the situation is, you decide, all right, even though my doctor says no, the insurance company is going to cut off benefits, I got to give it a shot. Go to your doctor and make sure your doctor provides a written report detailing the reasons why it's a bad idea.
Good call.
Give that to the insurance company. That probably won't make them change their mind, even though it should. But at the very least, you're putting it in front of them so that if you do go back to work and you're not successful, and worse yet, it causes some sort of exacerbation or deterioration in your condition, the insurance company is now on notice, and they've been on notice that this was a likely result. And now not only are they required to pay benefits, but now they're on the hook for potentially significant damages for having caused a further deterioration in your condition because they've insisted, against your treating doctor's advice, that you go back knowing full well that there could be significant consequences to your health, and they say, we don't care, you have to go back anyway. If they do that, they've exposed themselves to having to pay beyond just the benefits that they should have been paying in the first place.
Talking about getting back to work successfully from a disability leave. Point number two is this, James, provide a detailed list of accommodations, if necessary, to your employer. Yeah,
and this is probably more for the benefit of doctors or therapists that are listening. So if you have a patient that is in this situation, that is off work getting disability benefits, and they've come to you and they say that they're feeling better and they'd like to try returning to work, it isn't necessary that you say, okay, they're all better now and they can go back to work. That's not what's going to be required in order to give them that opportunity. What you should provide is your opinion, and generally speaking, doctors tend to be more inclined to give themselves the ability to say that this may or may not work, to couch their opinion in accommodations and restrictions and limitations. And so they'll say, it's okay for my patient to try to return to work. However, it's going to be important that they return on a graduated schedule, maybe fewer days per week, fewer hours per day initially, building up over time. or reduced duties and responsibilities, or any other accommodations in terms of the environment they're in, less noise,
Lifting fewer pounds.
whatever it may be, whatever is necessary for the particular disability their patient has, the doctor or therapist should be providing a list of accommodations that are going to be necessary in order to allow their patient to be able to successfully, or be in the best position to be successful in their attempt to return to work. It's important that that is couched in language that isn't definitive, unless the doctor really does feel that way, but that says it's okay to try, these are the accommodations that are necessary, and then we'll follow up in 2 weeks, a month, whatever it is, and see how the progress is.
And as you know, if we were to, briefly put on your employment lawyer hat for a moment, that accommodation from your employer is fairly mandated. There's a high threshold for them saying, no, we can't make that accommodation. It's really high, meaning, i.e., they can do it, and they pretty much have to do it legally.
Yeah, this is, we hear about this all the time on the employment show, and that requirement of accommodation is significant. It has to be to the point of unreasonableness.
Hardship, yeah.
And so undue hardship, thank you. And the reality is most of what we're talking about, a graduated schedule, a modified work environment, that's usually fairly easily achievable. There are circumstances where it's not, and that's probably a topic for the employment show to get a little bit more specific on. But yeah, you shouldn't feel badly about asking your employer for the accommodations that your doctor is saying are necessary for your return to be successful.
Okay, we got one more point to cover here. Getting back after a disability leave is this, James. If your return to work sets you back in your recovery, there you go. Get your doctor's support to get back on leave, though.
Yeah, this is really important. And when you are attempting a return to work, it's important to make sure that you are continuing to see your doctor on a regular basis. You should plan follow-ups. I would plan a follow-up for the first week after you've gone back, another for the second week, and then maybe 2 weeks after that, and then as needed beyond. The reason why you want to do it is because you want to make sure that there is a record in the medical file of your condition as you continue in your attempt to return to work, so that if there are issues that arise in the first week, you're having difficulty with fatigue, or you're having back pain, or you're having anxiety, whatever the case is, and that is worse, it may not be unexpected. It probably, for most people, when they go back, it's not going to be a smooth ride. There are going to be bumps, and that's fine. But you want to document those, not because you're trying to get out of being able to return to work, not at all, but because if after a month or 2 months, it is just too much, you're not able to do it, your condition has just gotten worse, and you are not able to continue, it's going to be much more difficult to justify that if there is no record of your symptoms being exacerbated as your return dragged on. If, on the other hand, you've continuously gone to your doctor and updated them on your symptoms as the weeks have progressed, then it's going to be very easy for someone to take a look and say, okay, yeah, very shortly after they returned, their anxiety increased, and that continued for the next 3 or 4 weeks. So that makes sense. Is that going to mean that your insurance company is going to reinstate you? Not necessarily. In fact, probably not. That often happens, which is why I say don't start unless you're optimistic you're going to succeed. But if they don't reinstate your claim, if they don't put you back on benefits after you're unsuccessful in your attempt to return to work, you're very often, as long as you still have the support of your doctor, you're going to be in a good position to be able to bring a legal claim and fight the denial of your benefits.
All right, good stuff. That was the topic for today. We'll take a short break, get to more of your questions, emails, and the website mydisabilityquestions.com. You can use that freely and anonymously anytime. That's where we're going to go after the break here on the Disability Law Show. Stay with us. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Disability Law Show. A few minutes to go. Thank you for your contributions each week. If you've emailed or used mydisabilityquestions.com, that's free and anonymous. Another place for you to ask your questions. This week we'll get to Laura. Thank you, Laura. Says, I applied for disability leave for depression and insomnia caused by grief, but my request was denied by the insurance company. I've appealed with a form from my doctor filled out recommending I take at least 6 months off work. If I'm denied again, James, what are my options?
Well, first of all, this is a pretty good example of what I was talking about off the top of the show, about mental health claims being denied, having a more difficult terrain than physical claims often do. And that is very much the case here in dealing with Laura's email. She's suffering from depression and insomnia, has been denied. She's chosen to appeal, and we see this a lot, and it's understandable because when you apply for disability benefits, if your claim is denied, your insurance company will send you a letter. And that letter should be detailing the basis for their denial. Often it's really vague and entirely unclear why. But after they've explained why your benefits have been denied, you're going to see right after that that it's okay, you can appeal. That's put in there for a reason. Your insurance company wants to be able to control the process for as long as possible. And so they put this in there right after they tell you they're not going to pay what they should be paying, because they want that to be the first thing you think of. You say, okay, you're not paying my benefits, but there's light at the end of the tunnel. I can just do this appeal. Surely, with another letter from my doctor, they're going to be able to understand that I really am disabled, so I'm going to just try this appeal. Why not? Well, the why not really is simply a matter of time. There are two time issues involved. One of them is the limitation period. If you are denied benefits, the day that you get that letter, the clock starts ticking. You have 2 years from that day in order to bring a lawsuit, in order to challenge the decision of your insurance company. If you don't within that time frame, that's it, you're done. There's nothing that you can do. Your insurance company wants to run out that time as much as possible, so they'll give you this appeal and they'll try and force you down that road so that you don't call a lawyer and bring a legal claim. The other issue, and what I think is probably the more important issue for most people, is just simply the issue of getting it resolved, because people who are applying for disability benefits by definition aren't working. They don't have income coming in, and for most of those people, that's going to put them in a very difficult position. That's going to mean that they are without money coming in to pay for all of the necessities of life, and unless they've done a really good job saving, which is real difficult for most people these days, unless you put a lot of money away or you happen to be independently wealthy, it means that the timing is critical for you and you need to be able to get your benefits reinstated as quickly as possible. So it may seem that actually appealing is a good route, because typically speaking, the appeal is going to be, will be heard and decided pretty quickly, usually 3 weeks, a month, sometimes 2 months, whereas a legal claim is going to take 10 to 12 months. Here's the thing. The appeal in almost all circumstances has almost no chance of succeeding. Your insurance company has no desire to reinstate your benefits or to approve your claim. They are looking for ways to not pay benefits. That's what they're in business for. They found a justification. Unless you've given them a really good reason to change their mind, they're not going to do that. And so when you appeal, you're basically just giving them that power, and you're delaying the inevitable, which is bringing a legal claim. And if you wait an extra month, 2 months, 3 months before you start that process, that means it's going to take an extra month, 2 months, or 3 months down the road to get it resolved. So really, if time is really the issue for you, you want to get the legal claim started as quickly as possible. Give us a call and we can get the ball rolling.
And it could be appeals. They might do it more than once.
I've seen the most I've seen in one case was 7.
That's crazy.
I've seen 7 in one case.
Yeah. Don't go down that road. Make that phone call, email James and his team, and get it happening. Thank you so much for joining us. Here is that number and email as we get out of here for this week. 1-855-821-5900. help@disabilityrights.ca, and just disabilityrights.ca, the website as well. Thank you so much. We'll catch you next time on the Disability Law Show.